Plan to allow the bail application not on the merit of the case, but solely on the ground of violation of the constitutional and statutory right of the accused person at the time of his arrest with conditions. Okay.
For delivery of orders, item number 31. 31 to 33.
31.
31 to 33.
Okay. Petition allowed. Allowed.
Mention. Worship, may I mention one CRP? There is an urgency in the matter, Malad, because Malad, the Kabha was held, which went against me, Malad.
Just a minute. Sir. Is there any other order for delivery? Yes, sir. Okay, yes.
Yes, Malad. May I mention, Malad, the one CRP? There is urgency in the matter, Malad. The Kabha was held, which went against me. Against that Malad decision, I prepared Malad the appeal before the Inter-Village Territorial Customary Court, and Customary Court Malad decided in my favor. Despite that, Malad, all of a sudden, Malad, additional Deputy Commissioner came and given Malad the restriction order, Malad, where I am undertaking construction activities.
This order was passed on?
Passed on Malad the 14th of this month, Malad.
Okay. At least when?
Malad, afternoon, Malad. At 2
No,
p.m.
no. Get it listed.
Malad, it is Malad,
Maybe it was delivered on 14 only.
Malad,
Get it listed.
Malad at 2 p.m. Malad.
No.
Otherwise, Malad, tomorrow is against Malad.
Why you did? Why you waiting for?
For collection of all documents, Malad, it took time, Malad.
No. Get it listed.
Malad, that means Malad, the matter will be listed day after tomorrow, Malad. Again, there will be hardship, Malad. There is a Malad, the one order permission given by the Deputy Commissioner.
Why you waiting for such time then?
Malad, we filed before Malad, Malad, appeal before the Inter-Territorial Customary Court, Malad. Inter-Village Customary Court, Malad, which passed in my favor, Malad. Malad, Deputy Commissioner, additional Deputy Commissioner, Malad, has no role, Malad. Even after the Malad, the AP Civil Code, Malad, Act came into force, Malad. So addition, Malad, have no jurisdiction at all, Malad. He has passed.
What order? Yes,
Malad, Deputy Commissioner has given me permissions for organizing Malad third edition of the Malad Siang Festival at my Malad the float of land, Malad. That permission has been given by the Malad the much before the Malad the permission Malad the dispute arose, Malad. Now after the
in the disputed area.
Yes, Malad. That is belongs to me, Malad. Deputy Commissioner has already given a permissions to me, Malad. Even village level Kabha was conducted, which went against me. Against that, again, I prepared Malad the appeal before the Malad Inter-Territorial Customary Code. And Inter-Territorial Customary Code has passed an order, Malad, and decided in my favor, Malad. It is in my position, Malad. We are organizing Siang River Festival, Malad. Everything is Malad going on, Malad. Now, all of a sudden, additional Deputy Commissioner who has no Malad jurisdiction passed and issued restraining order not to undertake any construction or any activities over the land, Malad. So that is the Malad simple case.
You said that this order was passed on 14. Way back
Malad, 14 is the Malad date of order, Malad. The communication was made lately, Malad. Just it will only Malad. It is a Malad small case, Malad. It will take only hardly Malad 5 minutes to Malad.
No, that is why you should wait for such time.
Malad,
On the day mentioned. It has to be listed. We need to see.
Malad,
No.
tomorrow again there is a holiday, Malad. Again day after tomorrow,
No,
Malad.
26.
Malad, since I am undertaking construction activities over the lane, on the side lane, Malad. And Malad,
No, I will not allow this.
Malad restriction order, Malad,
No, you deliberately waited for so 26. Get it listed.
Malad, now the restraining order is there, Malad.
No.
Despite Malad,
You'll be pressing for the interim. It will be difficult.
True,
I need to go through.
True, on
26.
26.
Lordship, I'd like to mention hearing item number 25, Lordship. The Honorable Court directed me to bring the original record of this matter.
Item?
25, Lordship.
Okay, what do you want?
Lordship, I need some time. I have spoken to the officers on the phone, Lordship. Then they have.
Okay.
I have taken consent also.
Okay. You're for this. You are for this. You are for?
For respondent 3.
Okay.
ADC Board of
Okay. Ms. Chiriba, here in the capacity of private.
No, Lordship.
Okay,
Or ADC.
that is Lana Council for the respondent number 3. Praise for some time, to
Bring record, Lordship.
produce a record. And when do you want, you said,
Lordship, let it be on 16th of December, Lordship.
and requested for listing this matter on 16 December, to which Mr. Lampu is for? Okay, for respondent, and who is for the petitioner?
Lordship, I am for the
Petition.
appellant, Lordship. On behalf of
Appellant, Mr.
K. Mena, Lordship. On behalf of Senior Counsel Ayapang, Lordship.
Okay, Lana Council appearing on behalf of Mr. Ayappa, Lana Council for the appellant has no objection. Accordingly, the prayer is allowed. List this matter accordingly. On 16th.
16th, Lordship.
Okay.
Highly authorized.
It is, Your Lordship. Should I beg to mention item number 15, my lord? My lord, some instructions are on the way, my lord. If my lord could fix the matter on 9th of December, my lord. I've taken
What
the
is this
consent-
matter listed for today?
My lord, for my lord, this was
This order for what?
orders, my lord,
Yes,
orders.
but
My lord, it has to be fixed for admission. My lord, could it be taken up on 9th of December, my lord?
for
For
in
admission.
admission column.
For admission.
Okay, have you informed the others?
Yes, my lord, I've taken the consent.
Okay. Mr. P. Denier, Lana Council for the petitioner. The other side is not present today otherwise.
My lord, they were trying
The
online.
state is also.
State.
Okay. Who represent the state?
My lord, the Assam government was trying online, my lord, but they could not connect.
Okay,
That's why they informed me, my lord.
and submits that he has a consent from the other side to get this matter listed on
9th of December, my lord.
9th of December. So, if father submits that the pleadings are complete.
My lord.
Okay, the matter may be listed for admission. Stop. Let's break, comma, let this matter be listed listed on 9th December on
For-
admission column.
In addition,
For admission, okay.
but there's an interim order, my lord.
The interim order passed earlier shall continue till the next date of this, till then, okay.
My lord, in item number 29, my lord,
Hmm.
the petitioner's counsel informed me that he has come.
Okay,
My lord, he could not come. That's his representative is present.
okay. So, you are Mr.
A. Gamre.
for the petitioner? Okay, Lana Council. Your name is not there?
No, I'm on behalf of the council.
Okay, appear on behalf of Mr. Vijay Jamu, Lana Council for the petitioner. Mr. P. Denier, Lana Council for the respondent is also present. And both the Lana Council raised for listing
My
this
lord,
matter
would
on
it be listed on 23rd of January?
23rd January. Okay. Let's wait for comma. Let this matter be listed on 23rd January. Okay.
Deep.
May I, Your Lordship?
Yeah.
I beg to mention item number 14. I'm mentioning on behalf of J. Sring. He went to attend his mother-in-law's funeral rites, so maybe fixed matter on 8th of December.
Hmm?
He went to attend his mother-in-law's funeral ceremony.
Okay. So when do you want?
8th of December.
Miss Somu,
Yes, Somu.
Lana Council for the appearing on behalf of the petition. Your name is there? No.
No, I'm mentioning on
Yep.
behalf of J.
Okay, appearing on behalf of Mr. J. Serin P. Lana Council for the petitioner. Praise for listing this matter on
8th of December.
8 December. The prayer
Entry
is
may be
allowed.
continued.
Hmm?
Entry may be continued.
Okay. The prayer is allowed. List this matter on 8 December accordingly. Stop. The interim order passed earlier shall continue till then. Okay.
Much.
Met this.
Hmm.
If I back to mention item number 6 also. Lordship, and this matter may be taken up after 2 weeks.
Why?
Lordship, conducting counsel, Mr. Yadav, Firmar Yadav is out of station on the medical grounds.
Is there any interim here?
No, no,
No interim. Okay. Mr.
deal on it.
Lana Council for the petitioner. Praise for. When do you want? You said after?
After 2 weeks.
Okay. Praise for adjournment of the matter Why you are seeking adjournment?
Lordship, conducting counsel is Mr. Kirmar Ado. Yeah, he is out of station on medical.
Okay. Okay, Mr. So-and-so. Some says the conducting council, Mr. K. Ado, is out of station and therefore pray for adjournment for 2 weeks. The prayer is not being objected to is allowed. Okay, list this matter after 2 weeks. Okay.
My lord, I beg to mention item number 5.
Item?
Number 5.
Yes.
Seeking adjournment for on behalf of conducting council Community River. He's in
Is there any interim order here?
There is an interim, your lordship. In fact, I insist on objecting the adjournment taken for such a long time, your lordship. There is a very
Settlement-
tribal issue. This is a settlement case, your lordship.
Huh?
This is a case of settlement between the parties, your lordship.
Okay.
Now they had come before the court with a settlement agreement wherein the parties, the court observed that the parties are not yet married. They came
Oh.
to the ground that they are married and therefore the POCSO
It was the wrong information.
wrong information, and therefore they were directed to file an affidavit to confirm that if there was a marriage between the parties, to bring in record the marriage registration of the marriage, your lordship. But then
When do you want, you said?
matter may be fixed after 3 weeks.
No, next week? Well, grant, but next week, since the council is not present, okay, Mr.
G. Tala.
Lana Council. Submits that the conducting council, Mr. K. River. He is out of station or what?
Yes, he is presently at Basar due to
He's out of
Panchayat
station.
election.
They have prayed for adjournment of the matter for a week. Prayer allowed. List this matter after a week. Stop. The okay, the interim order passed earlier, shall continue till then. Okay.
the process.
May I please, your lordship?
Hmm.
Lordship, I beg to mention item number 10 on behalf of conducting counsel, Mr. P.K. Tiwari. Lordship. With the consent of the other parties, this matter may be listed after 3 weeks, lordship.
Okay, you are for,
For
Petitioner.
conducting, yes, petitioner, lordship.
okay, Mr. Pai, Lana Council, for appearing on behalf of the petitioner and person.
And lordship, there is an
The
interim,
consent of the Lana Council for the other side. Praise for listing this matter after
3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks.
Lordship, there is an interim. Interim may continue, lordship.
The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply obliged.
I beg to mention item number 9, on behalf of.
Item?
Item number 9.
9. What was the item just now mentioned? It was 9 only?
10.
But it was 10, sorry. Okay, now you, okay, then leave that petition in person, huh? Earlier one. Okay, item number 9. Yeah, what you want?
Yes. I am for the respondent appearing on behalf of our sonnet.
Okay,
Be taken from the other party. Matter
Okay.
may be set after 2 weeks.
after 2 weeks,
Yes.
your good name?
R. Yaku,
R.
Yaku, Y.
Yapu, Lana Council. Appearing on behalf of Mr. Samat, Lana Council for the respondent, with the consent of the Lana Council for the petitioner in person. Praise for listing this matter after
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks.
May I please, my lord?
Uh,
My lord, I beg to mention one unlisted criminal revision petition, my lord, 3425. This matter, my lord, this matter was, I was mentioned before your lordship on 18/11/25, and it speaks on tomorrow, but it was mistakenly fixed. So it was, tomorrow is the holiday, my lord.
okay,
So, my lord, this matter, my lordship may consider after as a last item.
so tomorrow we'll take up this matter. You have mentioned for tomorrow.
My lord, tomorrow is a holiday, so it was wrongly, we have.
Okay, when do you want?
My lord, since I have some urgency, so matter may be taken after,
Yeah, sir.
yes, today, my lord.
Today?
Yes.
No, 26, getting listed on 26 then?
My lord, matter is fixed on, the trial court matter is fixed on 27, my lord, it's 313. Because we
We'll
have
take up on
already,
26. What is this matter about?
My lord, recalling of one witness, my lord. In that
26.
much.
Give the number. Oh,
My please, Lordship.
Oh.
Lordship, I beg to mention item number 11, Lordship.
yes.
This matter may be fixed after 2 weeks, Lordship.
Why?
Lordship, I have taken a consent from the respondent. Lord.
Okay, Mr. Indo, Land Council for the petitioner. With the council of the Land Council for the respondent. Pray for listing this matter after 2 weeks. If
Lordship.
prayer is allowed, list this matter. after
Lordship,
2 weeks.
interim dated 27/1/2025 may be continued.
The interim order passed earlier shall continue till the next date of this.
Lordship, I,
There is interim.
yes, Lordship,
Okay.
27/1/2025.
Okay.
Lordship, again, I beg to mention item number 30, Lordship.
3.
Item number 30.
Yes.
Yes, Lordship, I have taken a consent from the petitioner, Lordship. So this matter may be fixed for 2 weeks, after 2 weeks.
Okay. Similar order. After 2 weeks.
Item number 2.
May I please, Lord?
Yes.
Lord, this is the bail application. Earlier, there were 2 orders have been rejected by the session judge. And the impugn order I have placed on record, Mirror. It is at page
Impugn order
impugn order, Mirror, yes.
in the bail.
No, yeah, I have placed on the record of the Honorable Court, Mirror.
Hmm?
It is on the record of my lord.
Okay,
This is order dated 24th of July.
page.
Page, Mirror, I
What impugn order is
soon
there?
after
Bail?
exactly after the petition, Lord. I'm not having the pagination here, Lord, actually. I don't know how. The pagination is missing from my record, but maybe it is there before my lord. After the petition, Lord, first annexure is the impugn order.
Okay. What is this impugn order?
Lord, this impugn order rejects my bail application,
You have impugned this order.
impugned this order, my lord. And there is another order dated 16th of October, which has been passed long back.
Is it what? Revision.
This is the bail application, Lord, simple.
In the bail application, we have impugned this.
Yes,
Is it
my lord.
for-
Yes, my lord. This is the bail application, my lord, after rejection of my 2 orders by session judge. Since the second order, the judge has not supplied to me, so I have placed on the record the certified copy application showing that I have applied for the order and still I'm not getting the order. And even otherwise, the needful can be done based on the first order itself.
Let us see the prayer.
Prayer, my lord, is for grant of bail, my lord. Admit the instant bail application, call for the relevant record. And the prayer
Prayer
is
is for release only, not impugn the order. It's bail application only.
yes, my lord, this is bail application.
Mhm.
Admit the,
Simply that your earlier bail application moved before the session court has been rejected.
yes, my lord.
Okay. Yes. What is the allegation?
So, my lord, if I'm allowed to read the allegation, my lord, they are contained in the complaint, which is filed as annexure 3rd, my lord.
Hmm.
This is a complaint dated, my lord.
Okay.
Yes, my lord. 4th of June. And my lord, I am in the custody since 30th of June, my lord.
Since
30th of June, my lord.
whether case submitted in the charge sheet?
Charge sheet has been submitted, my lord.
Charge sheet
Investigation
filed.
complete, yes, my lord.
After when this bail order was rejected?
The bail order was rejected on 24th of July.
Okay, on July, whether the charge sheet was already there?
No, then it was not.
The second,
And
second bail
the
rejection order,
second order also, the charge sheet was not there.
not there.
Not there.
Do you have the copy?
No, my lord, even I don't have copy, but I have the information that charge sheet has been filed.
copy I don't.
No, the rejection order on,
Rejection order, yes,
what was the ground for rejection of the bail?
there is no ground that orders.
There is a
bail
private
has been,
signatory like.
bail has been rejected, observing that this is not the fit stage to grant the bail.
Well,
if I can read the-
when it was rejected, you said?
It was rejected on 24th of July.
No. Second one,
Second one is rejected on the 16th of October, but order has not been supplied to me. Despite my
have you
repeated,
applied?
despite my repeated request,
Have
and
you
finally
applied
then
for
I had
certified
to,
copy?
yes, sir.
Where
And
is
finally
the
I had to apply for certified copy.
Where
And
is the
I,
application?
so the application I placed on record, my lord. This is the second document after the impugned order, my lord. Application dated 16th of October.
What they said, what is the reply to this application?
To such application replies are not given, my lord. They are still
Okay.
sitting on the matter.
When?
And
when
they're not
it was
supplying the
filed?
order.
1610,
Yes, my lord.
okay.
That
So
simply st-
what is the new ground for bail this time you have taken?
But if my lord can allow me, my lord, first investigation is complete, my lord.
Hmm.
And this is a case,
No, charge sheet file, you said,
charge sheet file,
and
meaning,
charge sheet is there, entire police papers are there.
so
The
meaning thereby,
direct session court has examined, and thereafter he has rejected the bail.
no, my lord,
Trial commenced.
trial has commenced. There's no such requirement that I have to go to sessions again. I can come against that order before my lord because
Yes.
I have a good case before this honorable
That
court.
is true.
Uh,
That is why I wanted
Yes.
to know what is the ground for your rejection of the bail?
As I submitted, my lord, the judge observed that it is not a fit stage to grant the bail. And in the second order, I'm not aware because the judge's office is still not supplying the copy of the order, despite the fact that the order had been passed on 16th of October, as back as on 16th of October.
Hmm.
And we are in the,
You must have pleaded for grant of bail on merit only. It was disposed of on merit only after examining
I
the-
agree, my lord. That's my grievance before this honorable court,
Okay.
that I deserved the bail at the first,
but it was rejected.
it was rejected.
So
As
my question is, what is the new ground that you have taken? Only on the same ground?
yeah, my lord, I can argue my case before this honorable court, continuing from my first order itself, even leaving aside the second order. I'm comfortable enough to argue
No.
my case based on the first order without taking the assistance of the new
No.
grounds.
What I'm saying
Hmm.
is the Lanai Session Judge
Yes,
has rejected your bail
my lord.
after examining the entire records.
Record was not there before.
Record was there only. You said that the
No.
charge is submitted. It is before. the
Maybe I'm
session
not
court.
able to communicate properly. I can, if I can be allowed to submit again, my lord. When the first bail application came for hearing, record was not there, investigation was going on. Charge sheet was not filed. And after a lapse of about 3 months, I filed the bail application again. I don't know whether the judge has considered the entire record or what, or on what basis he has rejected. And I had to hurry to this honorable court because since June, I'm inside the jail and I had to make my submission before this court because if the session judge refuses or declines to supply me even the copy of the order, then I have been left with no other remedy but to move this honorable court.
We'll call for the record then.
My lord.
Okay.
My lord. That would be fair enough.
Yes. Mr.
Sushil Sharma, my lord.
Sushil. S.K. Sharma.
S. Sharma, yes, my lord. S.K. Sharma.
Okay. Then counsel for the petitioner. Stopper. Also heard Mr. G. Taro, then additional PP for the state.
Yeah.
Para. This is bail application filed under section 483 of the Bharatiya Nagarik Suraksha Sanhita 2023, seeking grant of bail to the accused Mohammed Salam Qureshi, who has been arrested in connection with the PS case number 40/2025 under section 64 within bracket 2 stroke 75 2 stroke 77 stroke 79 stroke 351 2 of Bharatiya Nyaya Sanhita 2023. Para. Issue notice. Call for the trial court record. Stop. The petitioner shall take steps upon the accused. Who is this? Where is the name of the victim?
In the application, my lord?
Is it POXO Act only? Not
No, it's not POXO.
Not POXO.
It's not POXO. The lady is a married lady,
Okay, major.
married even.
Huh?
Both of them are married.
Married?
Huh.
Who-
Complainant is married to someone
Okay,
else.
okay,
Yeah,
okay.
yeah. And the accused is also married to someone else.
The victim, whether the notice required to be issued to the victim? No, not required.
Not recorded in this case.
Okay. Then leave that, huh? List this matter. When?
My lord, if my lord, it is convenient.
Then
17th of
scan copy, huh? Scan
17th
copy of the
December.
trial court record.
17th of December will be okay, my lord?
17, okay.
Yes. I'm grateful.
Item number 3.
Three is, my lord, a question petition based on the mutual settlement, my lord, between the complainant and the accused party. There are as many as 9 accused people and 3 complainants. Matter has been settled between them, and hence this petition, my lord.
Which court?
But this is court in Alo, my lord. I have placed the order.
The case has
Last annexure.
been charge sheeted?
Yeah, charges has been
Okay, is pending before the trial court?
trial court, yes, my lord.
CJM.
Yes.
Hello,
Yes, my lord. I have placed the order. This is the last annexure, my lord.
last order where?
Yeah, last annexure.
Okay.
Judicial magistrate cum civil judge, senior division.
Okay, page.
Yeah, my lord, this is the 160. 160. This is for consideration of charges, my lord.
Okay, charge not yet considered.
Not considered.
Can call for the record?
Yes, my lord, that would be better.
Yes, my lord. My lord, now the matter is fixed for consideration of charges, my lord, as per the latest record, my lord, latest order, my lord.
By the way, what is the offense registered against the accused
But-
persons?
333 is non-compoundable, and my lord, the one is PDPP, my lord, the section 3 of the PDPP Act. And so far as, my lord, the PDPP Act is concerned, your lordship, there is a no objection certificate duly issued by the executive engineer stating that the property which has been alleged to have been damaged have been repaired by both the parties jointly.
Okay,
So it has been.
so they have,
compensated.
It was a very small damage actually to a door,
Huh.
and the whole case was out of scuffle and confusion, my lord.
okay.
A simple door of the residential quarter.
There. This is a joint criminal petition filed under section 5 to 8 of the Bharatiya Nagarik Suraksha Sanhita 2023 by the accused and the informant seeking quashing of the criminal proceedings. What is the number? Under criminal proceedings under GR number 01/2025, arising out of Mechuka PS case number 01/2025 under section 333/1 1152 stroke 127 2 stroke 143 stroke 126 2 stroke 351 2 stroke 3 within bracket 5 of BNS 2023 read with section 3 of PDPP Act 1984. On the ground of settlement of the matter, on the ground of amicable settlement between the parties. Okay. Issue notice, call for the scanned copy of the trial court record. Okay, Mr. Nete, appear on behalf of the state respondent. Staff, list this matter after.
17th of this matter.
Okay, list this matter on 17th
This is
December.
small matter.
Okay.
Item number 4.
This also, my lord, I am there. Actually, this, I'm impugning the order of the trial court, which was passed in a revision petition, which I've also annexed. Impugned order is also part of record, my lord. My challenge, my lord, to the order is that it has been passed without jurisdiction and by exceeding the powers vested on the judge, because the revision petition question was filed by the stranger to the criminal proceedings before the magistrate. Neither the revisionist happened to be the complainant in the matter, nor the revisionist is the accused. Still, the revision petition was entertained by the session judge, and the order was passed without jurisdiction. This is my ground. And the second ground, my lord, is that even if my first ground is not going to sustain, my lord, this revision petition was entertained and order was passed in an interlocutory order against which revision cannot lie. Statutorily cannot lie. So these are two prime grounds on which this petition is going to be prosecuted and contested, Lord. So my request is for admission of this, and then we can argue the matter at length. This is just for admission. And if my lord want me to read what is this whole matter about, I have no problem with that.
The order was, initial order was passed by
the session judge.
Initial order.
Initial order, yes, my lord, is at
147.
Yeah, my lord. This is the order dated 25th of July, 25th of March 2025, Annexure 3, my lord. Annexure 3. of March, my lord. This is at page 147. This was the order of the magistrate, learned magistrate, which was challenged in the revision petition. And in this proceeding, the revisionist is not a partner. As my lord could see, this is the case titled as State versus Binod Kumar Agrawal. State versus Binod Kumar Agrawal.
State versus
Binod Kumar Agrawal.
Vinod Kumar Agarwal.
Yes, my lord.
State filed against Vinod Kumar Agarwal.
This order was passed in a case titled as State versus Binod Kumar Agrawal. PS.
What case was this?
This case arose, my lord, from a complaint which
complaint lodged by the state.
Lodged by the petitioner herein, my lord. The petitioner, who is the petitioner before my lord, he had lodged the complaint. Diwan Natung is the petitioner before my lord.
The present petitioner lodged
the complaint before PS Itanagar.
Against
against Binod Kumar Agrawal. Binod Kumar Agrawal has not challenged this order.
Okay. Who is this Binod Kumar Agarwal?
My lord,
Then?
this is a private party.
Private party.
Yes, my lord. And this order was challenged.
What was the complaint against
Complaint under section 61 within bracket 2, my lord.
Binod Kumar Agarwal?
Yes, my lord. As my lord could see in the annexure 147, my lord, which
Ah.
is before my lord, my lord. The complaint was under section 61 within bracket 2, 3184, 316 within bracket 2,
Hmm?
366
Wait,
within 3
fine.
for cheating and fraud
Okay.
was the complaint
This
against the
is
private
against Binod Kumar Agarwal.
Agrawal. I filed the complaint. In my complaint, the FIR was lodged
Okay,
which-
okay. It was based on the FIR.
based on FIR. Based on FIR, my lord.
Then?
Then, my lord, investigation progressed.
Three.
During the course of investigation,
Hmm.
the investigating officer realized that one bank guarantee amounting to 4 crore, there were two bank guarantees amounting to 4 crore, around 4 crore each, is lying in a particular bank. And my allegation in the FIR was that he has taken this bank guarantee amount from me by misrepresenting to me, by playing a fraud on me. So the
Binod Kumar.
Binod Kumar. And this Binod Kumar fellow has placed this bank guarantee mortgage, placed this bank guarantee as his own guarantee with the revisionist NHIDCL, who later on filed the revision in which the impugned order was passed, for which I am here in this petition. So my case, entire case before the police was that this Binod Kumar fellow has procured money from me to get the bank guarantee made, and he has placed this bank guarantee before NHIDCL, passing it on as his own, promising me that he will make me subcontractor. Later on, my further argument before the police was, later on, this man backtracks and he could not make me subcontractor, and so he has committed a fraud on me. There are multiple allegations like he has made me to invest so much of money, crores of rupees money, etc., etc. So complaint contains the allegations about the money fraud running in crores of rupees. The investigation progresses after registration of FIR. During the course of investigation, my lord, IO realized that this BG, this bank guarantee, got to be procured by the IO and handed over to the complainant so that at least this money is saved. When I told him that this money is still lying in the bank and the bank guarantee is still not been encashed by NHIDCL, then he, applying his own wisdom, applied to the learned magistrate. Learned magistrate, applying his own wisdom, passes an order, which is before my lord, in the shape of order dated 25th of March, 2025. And based on that order, and then subsequent order, which was 23rd of July, 23rd of April, which is at page 156, my lord. 156, my lord. Page 156, order dated 23rd of April. Based on these two orders,
What is this 156 order?
23rd of April, 2025.
Hmm.
This is at page 156, if my lord has it.
Hmm?
If my lord has it, my lord, at page 156,
Yes.
order dated 23rd of April 2025. So my submission, my lord, respectful submission, my lord, before this honorable court is, based on these two orders, order dated 25th of March 2025 and order dated 23rd of April 2025, learned magistrate applying his wisdom directs the ICICI Bank and SDFC, whichever the bank was, to release the bank guarantees in my favor.
And then this order was challenged.
My lord, kindly bear with me for a minute. Then let me first make the things in correct perspective. So, my lord, based on these two orders, the bank guarantees have been released. And in this file,
Just a minute. What is this 23-4 order?
yes, my lord, this says that these FDRs and accompanying documents be released in favor of the
So this BG bank guarantee was freezed.
were released in my favor.
No.
Why did this order?
Earlier it was freezed.
It was free.
By
Yes,
whom?
correct. Lord.
By what order?
By order dated 25th of March, which is at page 147 before my lord. Page 147. Order dated 25th of March. By this order, the magistrate was pleased to freeze the bank guarantees. Yes, my lord, proceed. At the second page, my lord. Third, I'm satisfied with the ground cited, and then my lord, operative portion. At page 148.
The bank guarantees is valid only up to 34, 2025.
My lord? No, but this is the date for the BGs. BGs are put in the bank for a certain period.
So it's valid till 30/04/2025.
Yes, my lord.
Expired.
So expired or not expired, the magistrate ordered that these BGs be released in favor of the complainant, which is the petitioner before my lord. So if I can be allowed to proceed for the lord.
Yes, please.
After passing of these two orders,
Now just let us see the second order.
yes, my lord, kindly.
Okay, after this second order, 23/4/2025, what happened? What happened?
Yes, my lord, exactly. So after passing of this order, the bank pleases to release them in my favor. I get the BG amount, I get the documents which were mortgaged along with BG, and I am out of the bank after this order.
You have already received the amount?
Already received. Yes, my lord.
Okay.
That is very pertinent for the purpose of this case, my lord. Why I'm saying this, my lord? Because this NHIDCL people wake up after passing of 5th of March order and then prefer revision petition 25th of March, my lord. Date may kindly be noted. After passing of 25th of March order, my lord, these people wake up and file revision petition before the learned session judge. And during the pendency of this, against this order only, 25th of March 2025.
Not against
That's what I'm going to submit. And in this file, another order comes. They don't incorporate this order,
which one?
this second order, in their revision petition, nor do they inform the court below, the session judge, that another order has come. Now BGs have been released. So we want to incorporate these changes in revision petition. They don't do that. They stick to the petition, and judge also continues hearing in that petition.
Against 25/3.
25/3. And the petitioner herein.
But till then it was. Till then it was already released.
Correct. I'm coming on that. That is the thing which I'm going to highlight before my lord. Then, my lord, I appear, petitioner appears in pursuance of the court's order, district court's order. I was called upon to explain my position. I appear, I inform the learned judge, learned session judge, that I have already received the money. Nothing remains in this petition. This petition goes. This petition has been rendered infructuous because I have already received the money. If my lord would kindly see the prayers in the revision petition, nothing of the prayer was surviving on the day when I entered my appearance.
Whether your submission recorded by the session judge?
That is another thing, my lord, which I would be submitting in due course, my lord. submissions were not recorded. They were not properly recorded, but
Have you filed?
dates
any-
are speaking. for
Have you
themselves.
filed any objection to the
My lord,
petition?
that is also, I'm coming on that, my lord. What happened was that through public prosecutor, the IO, concerned IO, preferred to file a reply. If my lord could have impugned order, the learned judge laughs off the reply, saying that have I asked for the reply to be submitted to me? In the impugned order itself, he does not consider that reply. He does not consider my submissions that I have already received the money. And he continues to hear the matter in a dead petition, in which nothing was remaining to be decided. And order is before my lord, impugned order is before my lord, which is totally without jurisdiction, exceeding the powers, and passed in a petition which had already been rendered infructuous upon the pointing out of the petitioner, upon the pointing out of the IO.
In the criminal revision petition, whether have you filed any affidavit or any sort of nothing?
My lord, yes. On the first date of hearing, when I had personally appeared on behalf of the petitioner, I said I want to file a detailed reply. The learned judge was remarked saying, "What is the need of detailed reply, Mr. Sujit Sharma? You straight away argue the matter." So, since the matter was very short for me, I informed the judge just in the manner I'm making the submission before my lord that nothing remains in this petition. I made the categorical submission that okay, if you're not willing to have any reply in writing, then my submission may be noted that nothing survives in this petition. Petition has to go because I have already received the money. But just said, okay, I'll pass the order. And this is the order. Dates are speaking for themselves. Which activity happened when? Even the proceedings before the session judges are also dated. And even then, the dead matter was heard and order was passed. Directing the bank to...
Yes, can call for the record.
Yes, Lord.
Heard Mr. S.K. Sharma, learned counsel for the petitioner. Also had Mr. Loy, learned PP for the state staff. Have you made any other party?
I have made
Okay.
them only the
Just
party respondents. Petitioners are the respondents here. I've just flipped the parties of the revision petition.
This is an application filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita against this revision, criminal revision has been filed under section so and so. No, it's not a revision. It's criminal.
Is it
petition
criminal
only.
petition?
Sorry.
It's criminal. Sorry.
Under 528 of the Bharatiya Nagarik Suraksha Sanhita 2023 against the order dated 25/8/2025 passed by the learned Sessions Judge Yupia and criminal revision petition number 08/2025 under section 440 of the BNSS. Okay, stop. 2025, whereby the learned revisional court what is the direction of the revision court?
Directions are that
Or the operative part?
bank to take steps to release the amount in favor of NHIDCL, etc. In view of the above material, so-and-so, observe that the order passed by so-and-so is so-and-so is
The
dated.
Learned Revisional Code.
Para 17, my lord, is the operation. Para 17 is the operational portion. Page 44. The branch is directed to restore the bank guarantees.
Directed.
To restore the bank guarantees. So this order.
While setting aside, set aside the order passed by the Learned JMFC UPR dated 25/3/2025, and 24 is also there. The 23/4.
This the judge has, learned judge has incorporated after seeing the record, because the record was summoned.
And 23/4
When the record was
2025. In what was the number? In that case, JMFC case number
FIR
passed by the
Itanagar PS case number 38 of It is going in the name of Itanagar PS case number 38 of 20.
Okay, in Itanagar PS case number 38/2025 within bracket, There is a Jimma also.
There was a Jimma also.
Otherwise, what is Jimma?
Record of magistrate may also be
No,
summoned.
just you are confusing. You said that it's in the same. One is the one order is on Jimma only. What are you submitting? Okay, then set aside the order passed by, order dated 25/3/2025 passed by the Learned Judicial Magistrates First Class in Itanagar PS case number 38/2025, and the order dated 23/4/2025 passed by the JMFC UPR in Jimma application number 18/25. Filed under section 497 BNS in within bracket in.
Wherein bank was directed to defreeze the lordship.
No, Jimma filed by the petitioner.
Yes, for release.
Jimma filed by petitioner in ITA PS case number 38/2025. And directed to restore the bank guarantee number. So you have to write the number 0543 NBD G 000032324 dated 21/9/2023, and bank guarantee number 053 NDLG 000333124 dated 28/9/2023. Stop, para. It is submitted that who is not the party according to you? You said
NHIDCL and their officer Vivek Joshi and the state. And the same body party before in the revision petition.
Though they are not the party lordship, but the NHIDCL was the lordship is a company lordship owned by the government of India under the Ministry of Road Transport and Lordship. They upload the tender lordship, and pursuant to that tender, these was deposited lordship.
Submitted that the respondent number 1. Who is respondent here?
Is the NHIDCL.
And 2, within bracket NHIDCL, and its DGM Sri Vivek Joshi, bracket close. were neither parties to the FIR nor to the judicial proceeding before the Judicial Magistrate First Class UPIA filed a criminal revision petition filed the above criminal revision petition number 8/2025 on 28/5/2025, long after the BGs were already liquidated and returned to the petitioner stock. However, despite the revision being infructuous and the respondent having no locus standi, the administration judge UPIA entertained the petition and passed the impugned order dated 25/8/2025. Stop para. Issue notice. Call for the file code, scanned copy of the. It will be a scanned copy or it has already been disposed of.
Disposed of.
We can call for the record and call for the file code record.
My lord, and the magistrate's record may also be summoned.
Hmm?
In the fitness of things, my lord, magistrate's record may also be summoned.
Magistrate record also.
Huh.
Call
It
for
will be
the
along with the.
No, it will not. It will not. Now it will not.
trial code, call for a trial code record of
FIR, Itanagar PS case number so and so. Case number 35, 38 of 2025.
the criminal revision number 08/2025 within bracket NHIDCL versus state of APN and others. And the scan copy. Magistrate also dispose of?
No,
It's
that
not
can
a-
be scanned.
and the
That can be
scanned
scanned
copy-
copy
and
because
the
it's
scanned
there.
copy of the Itanagar PS case number 38/2025. Within bracket is state versus Shri Vinod Kumar Agarwal. Pending before. No, Vinod Kumar Agarwal, huh? From. No, it said scan copy. Have I said the from judicial magistrate first class? From the judicial magistrate first class UPIA. Staff, huh? Okay.
My lord, may I request for the stay of the operation of the order, computer, because this is creating a lot of confusion. Banks are confused, I'm confused, everyone is confused. And because amount has already been released, so this order is not going to be.
Now, what stay order?
Of the-
Amount is with you only.
Correct, my lord.
If you stay,
No,
then
actually,
you will be
bank is-
directed not to use
correct.
it.
A bank is getting confused because letters are being exchanged between, and bank is writing to me and then I'm writing to bank.
No,
So,
that is
that
what is
practice-
stay? What is stay?
My lord, this is a humble request, but if my lord.
Now,
consider-
what way the stay order can be passed? Because the money is with you only.
Correct, my lord. Correct. That's true. Operation of this, my lord, this direction which is
Okay,
given in para
independent.
17,
Okay,
para 17, only para 17 direction.
Okay. Upon hearing the learned counsel for the petitioner and having regards to the contention made in the petition, it is provided that the operation of the impugn order dated 25/8/2025 passed by the learned session judge in criminal revision number 08/2025 shall remain stayed
Until
till the next returnable date.
my lord, I'm deeply obliged.
Yes.
Obliged.
Sorry.
Your Lordship,
Yes.
I beg to mention item number 8.
8.
Yes, yes.
Yes.
Since Your Lordship, both the conducting councils are not available, so kindly this matter may be adjourned for today. And it may be listed after 2 weeks
You are for
for arsoner, for petitioner.
petitioner,
Yes.
Mr. M. Kambo submitted the conducting council, Mr. R. Sonar, Planning Council for the petitioner is out of station, therefore pray for adjournment of the matter. The prayer not objected. Accordingly, the prayer is allowed. List this matter after
2 weeks.
2 weeks.
Yes.
Okay.
Obliged.
Item number 7.
Since 7 is the same.
Is it?
Yes.
6 adjourned already, I think. 6 is criminal petition. How 7 is similar? Item 6 is criminal petition.
Sorry, madam. Yes, madam. In item number 7, madam, service supplement responded number 2 is not submitted. One is submitted, madam.
You are for the petitioner. Respondent never appeared. How many respondents are there?
Six, madam. Responded, madam.
Is it? Which item you said?
7, madam.
Item number 7 of today's list.
Yes, madam.
I think party's name?
What is name? Unique Insurance Company Limited versus.
No, I think you are in the wrong.
Oh, sorry, madam.
Hmm.
Sorry, madam.
You have anything to say on item 7 of today's list?
No, madam.
Okay. Item 7. None appears for the parties on call. List this matter after 3 weeks. Okay. After 2 weeks.
Item number 12.
May it please, Your Lordship.
Yes.
Lordship, direction was given to file any document which reveals the age of the alleged victim, Lordship. We have filed the additional affidavit.
Additional affidavit.
Yes, Lordship.
So there was a doubt regarding the age of the victim. This is bail.
Yes, Lordship.
Your Lordship, if I may take a glance at the record, Your Lordship.
Which one? Record.
Please.
Okay. Their record have also arrived. Okay. Let her.
There was an order by this honorable court to expedite the statement deposition of the victim.
Okay.
Which has not been done, and it's even the case record is not updated, Your Lordship. This is the case record is of 29/5/2025, Your Lordship. I've just been informed that the matter has been fixed on 20 January 2026 for deposition of the victim girl, Your Lordship.
Okay.
The court was to consider only once the deposition of the victim is been taken by the court since it's a POXO case, Your Lordship.
Okay, the deposition of the victim not yet recorded
Your
till
Lordship
date.
yes, Your Lordship is also well aware that the POs are on training now, Your Lordship. Therefore, the matter has been fixed on
POs, this is POXO Act, it must be
Uh,
PP,
the special
PP, special PP.
PP.
Oh,
a
PO
special
is the
court.
special PP here, still.
Yes. No, special court, Your Lordship.
No.
The district.
That is why I'm
sessions-
saying whether the POs are designated as a special PP POXO Act
No, the sessions court, Your Lordship,
in the session court,
No.
not PO.
not PO.
It's a PP appointed by the court.
Yes, special PP.
Okay, yes, please. And you are representing victim,
Yes, Lordship.
private?
Lordship, in the previous hearing, Lordship, 5 times the matter was called upon for recording an examination of the victim, but till this date, the examination has not been done, and we had not.
But then probably earlier, whether there is there any order
Yes, Lordship,
stating
we
that-
have annexed
There was a direction to me, Your Lordship, which I have
to take the impression.
actually apprised the respective court, Your Lordship.
Okay,
However, the matter was thereafter
so court
fixed.
has made that observation
Yes,
to expedite.
yes. Your Lordship will kindly see the order dated 28/10/2025, Your Lordship.
Yeah, the bail application cannot get me. Okay, do the need. So according to this, that means earlier bail was rejected only because the deposition of the victim was not yet recorded. Now thereafter probably this observation has been made to do the needful
Is
to record the evidence of the victim. Why it is taking so much of time?
on previous occasion, Your Lordship, the bail was rejected by the trial court on the basis that the investigation was at a very nascent stage.
Okay,
Your Lordship.
and then thereafter?
Thereafter, they had come before this honorable court.
Okay, so straight away before this court.
Yes,
Whether,
during the pendency, during the investigation period, Your Lordship, under 183, that is 164 of the CRPC, the statement of the girl was taken, Your Lordship.
okay,
Yes, the deposition is there, Lordship.
Subsequently, charge sheet was also filed, Your Lordship,
okay.
and thereafter they had come before this court for seeking.
Now you kindly see the record and what is the stage. How many evidences have so far recorded by the court, the learned court?
Yes, Your Lordship.
Charge probably have already framed.
Yes,
Yes, Lordship.
I'm not aware since the.
Whether the accused and the victims are somewhere related, nearby or something.
No,
Connected
it's a
now.
case of also
Unconnected.
it's a case not just of POXO, Your Lordship. It's a case of kidnapping as well as wrongful confinement for 3 or more days.
Okay, not POXO.
It's a gang rape, POXO, kidnapping, wrongful
POXO also there.
confinement for 3 or more days, Your Lordship.
Okay, that's right.
Because the girl was taken to Kerala and thereafter with the help of one local and the
Okay,
police
okay.
didn't.
Now the age probably.
The
Yes,
age,
Lordship.
What is the age of the victim at the time of commission of offense?
they had just filed an affidavit
Yes,
today, Your
Lordship, we have
Lordship.
filed
As per
the,
the affidavit, what is the age? What was her age at that
she
time?
was above 18 years only, but in the records, Lordship, it wrongfully recorded as 17,
No, recorded by whom?
recorded by police, but they have not submitted.
No, any certificate, any,
No, Lordship,
no school certificate, no birth
nothing,
certificate,
Lordship.
nothing.
Yes.
There must be some document at least, even if she didn't
Age
go to.
determination report is here, Your Lordship, at page number 24 and 20. Age determination has been done by the, it's in the charge sheet, Your Lordship. Since they have not annexed the charge sheet, I'll just take some few time.
Okay, please. You are representing victim? What is your submission? Okay, who is leading counsel for? She is representing private? Privately engaged. So you have objection to the bail? No objection. No objection. Okay. I think this because here is the case, probably it was taken from Itanagar to Guwahati and then to Kerala.
Yes.
Yes, Lord.
It appears that it's not, cannot be a kidnapping. Can it be?
As per the statement of the girl, she was on throughout the journey, she was fed medicines.
No possible.
That's
Yes, Lordship.
because
Lordship,
if
Section
the,
183.
if the age of the victim is to be calculated, Your Lordship, even the consent does not,
No, that is why I was looking for the age,
yes.
because it doesn't seem all through all those way from Itanagar to Guwahati, port there, thereafter Kerala, stayed for how many days? So many days it appears. Only the age is important here.
Yes, Your Lordship.
Now, if she was minor, of course, then all those things are immaterial. But then if she was major, then no case probably.
Yes. Your Lordship, this is the age determination report. A medical board was constituted, Your Lordship.
Hmm.
Uh, the
That is,
age-
Lordship, ossification is not there.
This is the ossification.
Hmm.
This is the ossification, Your Lordship. The charge sheet consists of the ossification. Lordship will see X-ray was done
Hmm.
and teeth were dental examination was done, and the age is shown to be 16 to 18 years.
16 to 18 years.
Yes.
So advantage goes to
The no, in juvenile cases, Your Lordship,
Hmm.
in case of where the accused is
where
a
the
juvenile,
victim.
these the 2 plus would be for it's for the juveniles, Your Lordship.
Hmm.
Whereas in POCSO,
For the victim.
it would be minus. If it's 16 to 18 years, it will be taken as the 14 to 15 years, Your Lordship. So if the age is to be because
See,
ossification.
that is why I'm saying to produce some document.
Yes, Lordship. We have filed the additional affidavit, Lordship.
What the additional affidavit says.
Annexure 5 is consists of birth certificate and
Birth certificate?
birth certificate, Lordship.
Okay, where is?
Today only we have filed in the morning. That's why it took time. We were unable to get this.
Okay, as for the birth certificate, her age is?
Lordship, it's 19. And if Lordship will peruse the annexure B also. Recently,
When the incident took place?
Lordship, the FIR.
You carry on. Miss
Yes.
Jenny, you carry on. When the incident took place?
Lordship, FIR was lodged on February 11, 11 February 25.
25.
Yes, Lord.
No,
Date of
6/1/25.
The accused was arrested on 11 February 25.
And an incident took place on
9/12.
9/12/24.
24.
Yes.
I
9
think
12
her date of birth is 12 to 2006.
Six.
Then she was 19. No, yes.
She was not 19, Your Lordship. If that even the death birth certificate is to be considered, Your Lordship, if Your Lordship will note down that her birth
18 plus. 24. Incident took place. Incident happened in the year 2024.
9/12/24, Lordship.
9/12. It's 18 plus only.
But the accused
So
was
that birth certificate was obtained when?
no, it was not obtained, Your Lordship, but the birth certificate has been produced by them before this court for the first time.
34/24, date of issue, Lordship. There is
34. After, before incident, it appears.
yes, Lordship. In annexure B also, if Lordship will peruse, there is medical certificate, Lordship.
Have you served copy of this?
I have just received this copy, Your Lordship.
You have received?
Yes.
Lordship, in the medical receipt also, it says that 19 years very clearly. Where now at present.
Medical?
Yes, annexure B, Lordship, page number 50.
What is this?
It's
This medical, this is recent.
she's pregnant, Your Lordship.
She is pregnant with another husband, Lordship. That is the point.
Oh,
Now, 18 weeks and 05.
no, not those two boys.
No, Lordship.
If there's no reference to the husband as such, neither in the petition nor the report, the medical report says anything of the husband, Your Lordship.
heard Mr.
Essington, Lordship.
Essington, Learning Counsel for the petitioner. Also heard Ms. T. Jenny, Learning Additional PP for the state, and Ms. B. Marde, Learning Counsel appearing on behalf of the respondent number 2, victim, huh? No, just not victim, yes, victim, huh? Para. How many petitioners?
One.
Only one.
Yes, Lordship.
What about the other accused person?
He has already been discharged because nothing was found against him during the statement 183. When she had given the deposition, a learned magistrate discharged the person.
Okay,
I am alone only languishing behind the bar, Lordship.
so 164 is 164, 183
Yes, Lordship.
statement is there,
Yes, Lordship.
and she had implicated you only.
Yes, no, she had implicated both of us, but it was the finding of the magistrate that the other guy has nothing to do with it. Only he was transporting the tempo. The other guy, he took me and the victim to the Guwahati railway station only. That's all. So, the magistrate discharged him, Lordship.
Is it?
Yes, Lordship.
I've seen somewhere that statement
Yes, Lordship.
that
Page number
both of them committed the alleged offense,
Yes.
isn't it? She has changed in our 164 statement.
Yes. There are two ones, 183 is a statement,
Okay.
Your Lordship.
Two.
Two 183.
Probably I must have seen the first one.
Yes. The second one, so she has.
She is
has
inconsistent. That
admitted-
means she is inconsistent.
She's inconsistent. Second one, she has admitted that she had an affair with the present applicant here in Your Lordship.
Okay.
And therefore, subsequent to this statement by her, most probably the court did not find anything alleged against the
Okay.
other.
Mm.
The only criteria here was to decide on if she was a minor, Your Lordship. Nothing as such, because the statement of the victim is also not consistent.
Yes, Lordship.
And therefore, only the deposition was to be, the court was awaiting the deposition.
Hmm. The petitioner filed this application under section 4A3 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for the release of the accused Akash Ali, who has been arrested in connection with the ITA Women PS case number 01/2025 under section 7T within bracket 2/137 within bracket 2/127 within bracket 3 of the Bharatiya Nagarik Suraksha Nyaya Sanhita 2023, read with as a BNS, read with section 6 of the POCSO Act 2012. Start. Para. The case of the petitioner is that based on the FIR, a written FIR, lodged by the alleged victim, the above PS case was registered against two accused persons and two accused persons under the above sections, under the aforesaid sections of law. Stop. The accused was arrested on 11/2/2025, and since then, he has been inside a custody. Stop, huh? It is submitted that upon completion of investigation, the police has submitted the case into charge sheet against Have you annexed charge sheet or charge sheet is here?
The charge sheet has not been annexed. No.
Okay, is it here in this record?
There in the record, Your Lordship.
Charge sheet were submitted or filed against both the accused.
Yes, Your Lordship.
Charge sheet. Against two accused persons, including the present accused, for offense under section 64 within bracket 2 within bracket M stroke 137 within bracket 2 BNS read with section 6 POCSO Act. So at the time of framing of charge, the other accused has been discharged. Okay. Is there any order is there on record?
It should be there in the record, Your Lordship, if I may.
Earlier, the bail application moved before the Lana Session Court has been rejected on the ground that the case was still under investigation. Stop. The Lana Council for the Petitioner submits that there is a change of circumstances as the case has already been submitted into charge sheet and a charge also framed against the accused. Stop. Do you have the copy of the order framing charge against the accused?
It should be there in the, if I may, Your Lordship.
This is the record.
That's the record. If I may assist, Your Lordship.
Just a minute. Huh? A moment.
Record में नहीं आना चाहिए.
Against the accused. Okay, just a minute. Huh? Charge or frame against the accused, the present accused. for offense under section 72/137(2)/127(3) BNS read with section 6 of POCSO Act. No, this is only cognizance, just a minute. This was 3. Okay, not that. Charge was framed against a present accused person under section 64(2), 64(2) of BNS 2023, read with section 6 of POCSO Act. Where is the discharge order then? Is there any separate discharge order? After framing of charge only it appears, because the by this order there are no, it has not been mentioned.
Your Lordship, if I may go through.
Please. However, subsequently, just the another accused has been discharged based on the statement of the victim staff para. As per the police report, the age of the victim has been shown as 17 years. However, however, the learned counsel for the petitioner, by filing additional affidavit, brought on record the birth certificate of the alleged victim. As per the birth certificate issued by the registered birth and date Surukhetri CHC on 30/4/2024, her date of birth is recorded as on 12/2/2006. Stop. The incident took place on when the incident took place?
9/12/24.
9/12/2024. Okay. It appears that at the time of occurrence of the incident, the victim was major, aged about Okay, what was her age then?
Your Lordship, as per the the
18,
age
18 years, huh?
determined
18 years. How many, how many months? Eighteen years, summer, huh? How many months? 8 or 6 months? Being born on 12 to 20,
should be
2006.
10
Okay.
months if
Okay, 10
12
months.
to
Okay, 10 months, okay. Yeah, put there in view of the, about it, prima facie it appears. Okay, start with that. The records also record also shows that now, sorry, the Lana Council for the Lana Council appearing on behalf of the victim submits that now the victim is married to another person and she is, where do we find that she is pregnant?
she's 18 weeks 2 months pregnant. Your Lordship,
Okay.
find it
She is okay. Is under gestational age of 18 weeks 2 days. Is on 25/8/2025. In view of the above, and considering that, considering the long detention of the accused, this court is of the view that the accused can be released on bail. Stop. Accordingly, this bail application is allowed. The accused is directed to be released on bail on execution of a bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the Lanit Trial Court. Special court only.
Yes, Your Lordship, I would just pray, Your Lordship. My submission with regard to the age determination report may also be recorded, Your Lordship.
Hmm.
Since it's a part of the charge sheet, Your Lordship, depose it accordingly, Your Lordship, because the additional affidavit that they have filed, the birth certificate that they have obtained.
No, I say that as per the records, she is 18. How much her age as per the record?
As per the age determination record, Your Lordship, age is 16 to 18 years.
Okay, as per the in that sentence, then correct that sentence. As per the record, within bracket age determination.
Shows she's 16 to 18 years.
Okay, that was done by whom?
It was done by the medical board constituted after
Okay, age determination examination. The age of the victim is shown as 16 to 18
years.
18 years. Okay. However, this. Okay.
His Lordship, I also
See,
could not find the discharge.
It's not proper also under the circumstances. He is already married to some other person.
Yes, I understand that. Your Lordship. But what I'm trying to portray is, Your Lordship, the documents, because obviously in the trial, the age will be an issue.
Yes, yes. This when she appear, she is yet to appear before the court. Now she will clarify what was her exact age.
Exactly, and that can be always be
And then if she don't, probably she will come along with the birth certificate also, since it was not on record.
seems, Your Lordship, since they have
So,
no objection to be.
At the time of
It was,
defense, they will also produce
it was only during the investigation.
investigation. This would have been actually
No,
produced.
no.
It was after completion.
During the investigation, the birth certificate was never produced before the IO, and therefore
Hmm.
not having not asserting as to which document her age could be determined. Therefore, the ossification, the last option for the age determination, the ossification was done.
When the ossification was done,
It was done, Your Lordship, just the date of the ossification is given. It's on 13/3/2025, Your Lordship.
2025,
Yes.
much before that, 34/2024, she has a birth certificate. Probably she wanted to implicate.
Yes, Lordship.
I'm not aware of that because
Hmm.
it will be a disputed point of time, but then
Pro-
ossification,
Maybe.
since the ossifications
Hmm.
show,
Trial will prevail the truth, Lordship.
Hmm.
since the
Okay.
ossification was done, Your Lordship, that's
Mhm.
my humble submission, because not
Yes, yes.
not producing any documents during the investigation, the last
Should
option
have,
was
actually, no? Yes, correct.
Also, Your Lordship, I have gone through the
So-
records.
Hmm.
The records do not speak about the discharge of the other accused. He was granted bail on previous occasion, Your Lordship. But then with regard to,
There is no record, it appears, because this subsequently, if he made a prayer with separately, that's different issue. But then you said that the victim has not yet been examined.
yes,
So after framing of charge, if she has not appeared, then she was not examined. So based on the earlier statement,
yes,
if the court has discharged, then it should have been at the time of framing of charge only.
Your Lordship, that was the, if Your Lordship,
Hmm.
while hearing this matter, Your Lordship,
Hmm.
the prosecution has placed the X versus Rajasthan, that during the trial period, the bail should be granted or not, Your Lordship.
Mhm.
That was placed before this honorable court, and it was the direction and opinion of this court that even in X versus Rajasthan, the court has in fact stated that the in POCSO cases, the victim statement ought to have first been taken, and then the
Right. That's true.
bail
That's
should be
true.
considered. And
Hmm.
therefore, this court opining that at least the deposition of the victim has to be taken, and therefore this
True.
matter has been coming up, and those directions were issued.
Now, because from here, from the records, it appears that there is something. So that is why I doubted from the statement and the activities and the conduct of the victim as well as the, of course, accused. That was I insisted him to produce the certificate. There must be some certificate. Okay. To be executed before that special judge POCSO Act, huh? With the on the following condition, then the normal that the accused shall appear before the trial court regularly on all date fixed by the trial court. Fixed. All date fixed for. Fixed by the trial court. That then the paragraph that he shall not directly or indirectly. Where is the CRPC? Applicant shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such facts to the court or to any court staff. That the accused stroke applicant shall not leave the jurisdictional court without previous permission of the court. Huh?
Your Lordship, if I may, Your Lordship. There's one point, Your Lordship, since the person is not from the state, Your Lordship. Both his permanent and the present address is in his arrest memo shows as from Barpeta.
Okay, then on execution of a bail bond of 20,000, huh, with two sureties of like amount, one of which shall be the resident of Arunachal Pradesh. Okay. Then in the last, that the accused applicant shall provide his proper present and permanent address along with the telephone number.
Yes. Your Lordship has stated that the one of the surety shall be from the state of Arunachal Pradesh.
Yes.
That would suffice because otherwise normally what the
Yes, I know.
they come and state citing the apex court order that local surety, it's not a mandate, Your Lordship. I was in fact praying that who may be the surety be even from his place, Your Lordship, having either a government servant or having a property at that's
Resident of Arunachal Pradesh. We'll say resident. Okay.
Bailor itself is a local person.
he's
Here
not a
in the-
bailor, he's an applicant.
Yes, the applicant here itself is a local from Arunachal.
Okay. Okay. It's not accused applicant. Accused only. Okay. With the above this bail application stands allowed and disposed of. Okay.
Highly obliged.
Yes.
Item number 13.
My lord, on last occasion, CDU is called for, my lord.
Okay. So what is there in CD? What if the bail, just a minute, huh? What was this case about?
Sir, this case is
Register against the accused for?
30.
Map,
Eight.
made, list Lordship.
Hmm.
Lordship, here, I will directly take Lordship to Annexure 4, page 21.
No, just a minute. Let us see the allegation. I just forgot. What is the allegation against him?
Allegation, say page 14, that type copy, Lordship
Page
will find
14?
it. Yes. type-
Where is it? Page number 16.
type
Page
copy,
number 16, my lord.
16. 14 is the register.
Type copy is page 16.
Yes, Lord. 16.
Threat and extortion attempt through WhatsApp.
Here, there's a allegation is basically of threat and extortion attempt through WhatsApp. However, Lordship, may I read the FIR, Lordship?
Yes.
Respected sir, most humbly, I'd like to inform you that on 5th September 2025 at around 8:15 a.m., I received a WhatsApp message from unknown number so and so. Now I replied to the message asking who. On the very next day, that is on 6th September 2025 at around 7:50 a.m., I received a WhatsApp call from same number. The call lasted for about 29 seconds, during which the caller informed me that a letter would be sent to me on WhatsApp and I must fulfill the demand mentioned therein. Immediately after the call, I received a letter from WhatsApp from the same number bearing letter head titled National Socialist Council of Taniland signed by Anthony Toke. So it's very important here. Commander-in-Chief, United Tani Army. The said letter with enclosed herewith contains a demand of rupees 5 crore only and threatened me with dire consequence in case of non-payment. I am deeply distressed by the threat and extortion and I request your good office to kindly register my complaint, FIR, investigate the matter and take necessary legal action against the culprit.
Okay.
My WhatsApp number on which threatening message and call was received by is so and so. Lordship, after this police has investigated and during investigation, I was arrested, but however, prima facie, I'm not related to this affair.
Okay.
At the time of arrest, the arrest intimation was given, but it was not clear. However, there is a letter to the learned judicial magistrate first class where grounds of arrest were there. And basing of the ground of arrest, Lordship, what happens that one of the co-accused was granted bail by this honorable court on 13/11/2025, that saying that the ground of arrest is not
Okay, just a minute.
generic in nature.
What was to be seen here in the case here in this case, because earlier, I now remember that we have heard it.
Yes,
And the ground of arrest was also furnished to him, and
Yes.
according to him, it is not the detailed one.
yes, that is exactly almost the same situation, my lord, here.
Hmm.
Here also. The letter of intimation that was, which my lord has earlier granted bail. That same kind of letter intimation that they are saying that this is not the ground of arrest.
No, bail was granted where ground was not furnished.
Yes, my lord.
There is a case where the ground is there.
Yes, my lord. Here, letter
Ground
of
already furnished,
intimation,
yes.
page number 26, my lord.
Yes, arrest intimation.
Yes, my lord.
So here the ground has also been given, it appears.
Yes, my lord.
So what was to be seen here in the case study here in
My lord, case diary, my lord, that is the comment made by the IO of the case, considering the grievousness of the, since my allegation here is section 13 of UAP Act, my lord. This alleged accused person, they were part of the, they were part of
Just a
the,
minute. Your earlier bail application was rejected by the trial court
Yes.
yes, ma'am.
on
Oh.
what ground?
On ground, on merit. Lordship.
On merit.
Yes.
So there you did not take the ground of
No.
not furnishing the arrest intimation.
Lordship, today also.
Was that also one of the grounds for taking bail before the trial
No,
court?
no.
That was not, and here
No.
you have taken this ground.
No, Lordship, they're not this ground. Lordship, I'm coming on parity.
Oh,
Because one of the co-accused was.
co-accused, whether in the case of the co-accused, also whether the arrest intimation was given to him,
Yes, same, similarly.
same.
Yes, same. Everything same. Only name has been changed. And when forwarding to the judicial magistrate first class, they have only given for all four accused only one ground of arrest. They have written in a very generic way, not specific that this person have committed this crime, not in that way. That's why everything is same. Only they have changed the name and they have typed the
Here is a difficulty because I have a different mind.
also yes.
So that way, if you want to take chance on parity, you can. Otherwise, for me to, because this is sufficient, it appears.
Yes, ma'am.
This is sufficient.
Yes, ma'am.
So here how do we expect the police to write exactly the words or the sentences that we wanted?
Yes, ma'am. And in one of the latest judgment also, my lord, this Darshan Singh, my lord.
What it says?
State of Karnataka versus Darshan Singh, my lord.
Hmm.
Here in that case also says that, my lord, there is no specific format of the
No
ground
specific
arrest.
one. That
Yes,
is why I'm saying.
yes. So,
No specific format, but thankfully they have this format they have created.
yes, ma'am.
Yes.
And then this arrest intimation, everything has been given here. And beyond this, if we expect, means I don't think that they will appreciate. Anyone will appreciate.
Lordship,
If there is a specific format, yes, no, particular words, using of words in the arrest intimation, then of course we can, yes, that is not there, that is not there. Even in the case where the tick mark is not there also. So this is not tick mark. It's simple tick mark also if they missed out.
Yes.
That's fine, we'll agree. But then here is the case where there is no format as such. And then he has given so many things, up to 7, serial number 7. And everything they have provided. And then below also acknowledgement by the arrested accused person also clearly certified
Yes, ma'am.
that I have been informed of the grounds of my arrest. It covers everything. And my right to legal counsel as per section 47 and 48 of BNS 2023. Another circumstance,
And my
where is the ground? Where is
Or
the
my lord, arrest
scope?
ground of arrest should not necessary should be in written one, my lord. That's why, my lord, in the
So
Darshan
that
case,
is why I would like to defer, but then instead, if you want to take chance, I can defer it.
Lordship, now I totally agree, but however, I like to assist this honorable court by that when Lordship wants to defer, then there is only two options will be left.
Yes.
Either to follow that judicial prisoner or otherwise refer to higher.
I refer to chief.
Yes.
But then that is why I'm giving you option, another option, to take chance with the same person, same
justice, my lord.
justice who has passed this order.
Again, we have to go to Guwahati. Then at that time, I'm not sure if we can file this petition there. There will be jurisdiction issue also. Lordship may, for this matter only.
Because that will
For
amount
the-
to
Yes.
deferring the the order of the
Yes.
coordinate bench.
Yes.
And in that case, what generally we do is we have to refer it before
Yes, my
the,
lord. Yes, that is the
Chief
only option.
Justice.
Yes, madam.
so that will take more time probably for
Yes.
you.
By that time, I'll be out on default bill. So, Lordship, we can do one thing. By granting this bill, we will make clear that from next time. Because written is also what I have gone through this
I have
bill
understood.
application. That written format is also not required.
Yes, I've understood that. I'm not convinced.
But Lordship, by the time if I go there, and moreover, Lordship, this is pro
Because
bono
they-
case also. That I don't think so that we have to take legal aid at Guwahati, Lordship. So by taking legal aid and filing there, then already 71 days already there. And moreover, Lordship, here, I like to place one more judgment where it says
And then one option, another option is that Lanet special PP challenge the earlier order.
yes.
Yes.
That is another option.
Lordship, I like
I
to
think because you, by now, since this court has been making so many observations,
Yes.
that this ground of arrest is to be furnished or intimation is to be given, or else you take action against the IO of the case who did not furnish ground of arrest. I have made today's order,
yes, totally.
3-4 orders, I have made this observation that action initiated against the IO of the case himself, because despite of so many observations, why they are not making this observation. And in this kind of observation, the ground of arrest, because this you'll face now, even if after giving this kind of arrest intimation, if the petitioner challenges, petitioner claims
Yes.
the right, then there is no option. Once if I start giving, there will be no option for the PP or for the police, because
Right.
police would not know what to write then.
Maybe, no?
So then probably it's a fit case that the PP should challenge, because in Arunachal, how many cases? So many cases every day. You'll face the same.
Yes, my lord. In that case, the SIT should endorse me, my lord, because as of now, there is no any endorsement on the
What
part.
enforcement? You are the Lani Council. You have to inform them
My lord,
unless challenge.
yes, my
Unless
lord.
you challenge this.
On my part, I have furnished them all the bail orders and all. And
Bail order, but no. So in a case, here is a case, specific case where he says, where the counsel, the petitioner claim is that although the arrest intimation has furnished, it is not satisfied or it's not sufficient.
my lord,
Then according to this, it appears if you think that this is sufficient or beyond this, what more we can furnish, then you have to challenge.
my lord.
Because even after furnishing the arrest intimation, if they claims that it's not satisfied, since there is no specific format, then you have to challenge this. Beyond this, what more we can furnish?
Yes, my lord. On last occasion,
So
we
this bail order need to be challenged if you are aggrieved. If you're not aggrieved, you can't say anything.
yes, my lord.
Even for the state also, if you have.
In fact, on the last occasion, has argued with in the same case, you know,
Mhm.
because this case was stacked along with another case from the same arising out of the same FIR.
Yes.
Even on the last occasion, I just relied on the same order that my learned friend is pointing out, Lordship. The same the same FIR, but there was certain, it was not same, two accused were given one notice.
That is different again. Then in that case, in respect of other, it was not furnished. They have a case.
No, Lordship. No. This is there, Lordship. I think.
So,
Lordship, one more thing. I like to, Lordship, one more thing is that here maximum punishment is 7 years. So on the last occasion,
yeah, I've understood, I know, but then the basic lies here only.
Yes.
The intimation. Okay. So here, that is why it's good that you assist, you're assisting and then not insisting.
Yeah. Lordship, what I'm saying is that because when even where there is a, I have on the last occasion I've given one judgment also 2012 1 SCC 40 married.
No, where is the ground, the not furnished, the ground of arrest? Where have you stated? It's only submission or have you stated here? There is a contention also.
Lordship, here I have this seven on 7 I have said that married.
Yes.
It is pertinent to mention in that only one notice under section 47 48 was provided to the relative of the present alleged accused person. Furthermore, the requirement of arrest in sufficient details and specific in notice as mandated under section 47 48 of BNSS are not being fulfilled in
No,
the present.
no, there is a statement then in that case.
Yes. Furthermore, Lordship, if this also forwarding to the judicial magistrate, which last time my learned additional PPF also argued that intimation also is very vague, Lordship, there, ground of arrest to the intimation to the magistrate also is very vague.
Earlier, what did you do is that even if the verbal information, verbal intimation is also, but then now you see, despite of giving such a written intimation and a certificate acknowledging the receipt and information or the ground being informed about the ground of his arrest, it will be difficult. So I think you take chance, just take chance once, and then in the meantime you take steps.
Lordship, here there will be jurisdiction issue, Lordship.
No, he will come.
Lordship,
He's coming after 3 weeks.
Lordship, by the time I'll be eligible for default also. Moreover,
But you see, but for this ground, your bail will be rejected only.
Lordship,
But for the ground that you are submitting, except for that ground, otherwise your bail will be rejected only on merit. That's why if there is no statement, then it deserves a rejection.
No, Lordship, here I have clearly stated in paragraph 7 that no ground of arrest.
Yeah, that is why. So then in that case, we have to appreciate, we have to discuss the ground, whether ground furnished or not. But then the ground, it appears furnished. But you say that parity on the same intimation, intimation of the arrest.
Yes.
Bail was granted that it was general.
Yes, Lordship.
Generic and not particular, not specific.
No, Lordship, para 6 I have said, be it as in may one of the co-accused, namely Marley, arrested in so-and-so case number, prepared a bail application number so-and-so before this honorable court.
Yes.
And this honorable court, while disposing the aforementioned bail application, observed that the notice under section 47, 48, which was furnished to the alleged accused person and its relevant relative at the time of arrest, there was no specific ground
or arrest.
Was mentioned.
Yeah, that is what I'm saying. So beyond this, what more specific information can be given? So here I differ, I say. Even if I pass also, I'll be differing, but that will be difficult. So now I'm not in a position, not in a mood to forward it before the chief. And then if you can challenge, it will be better. Because this might not cover even if I send it, forward it before the chief also. But then your challenge would be better.
I will discuss.
And in the challenge itself, if the court find difficult, then it will refer to the chief, high court.
I will discuss with.
That will be better. Okay. Mm. Please this matter after 2 weeks.
Look,
Mm.
Just one case, even on last occasion, I was certain, it's a, if I can just reduce, if I can just read,
Yes.
It's also 2025.
Mm.
Kasir Reddy, Upendra Reddy versus State of Andhra Pradesh and others. In this case, while dealing with the same with Vihan case and others,
Mm-hmm.
there is one particular paragraph which has shown that in that case, how the police had made an arrest. So the police, while giving an arrest intimation, I'll just read out, has given that the ground of arrest given by the investigation officer are that in the arrest intimation they have
Yes, yes, yes.
you are the key person in organizing so and so, liquor so and so, during so and so, suppressing of the material so and pursuance of that, gist of the case election, and you have been threatened by so and so, you're responsible for so and so for the only on that you
Making allegation.
you have been taken and therefore you are arrested. A small paragraph
Yes, yes,
which
yes.
reflects the
Here also the section is mentioned. Only he says that section should be explained.
no, if there is
No, what his submission, what I'm saying. Their explanation is given.
yes.
Yes. Okay. Anyway, after 2 weeks. He's coming after 2 weeks.
Lordship, today one will be out and other will be.
Yes, I understand.
looking.
But Mr. Bore, I'm helpless here. No, we don't want to go into that deep now. Let him give some opportunity if there is. Okay.
My lord.
Okay.
Obliged.
Item number 16.
Yes.
Service upon respondent number 2 to 660.
What is this IFO?
I have no idea.
Okay. So service, my counsel for the applicant has not yet, oh, you have not yet taken steps.
I have taken a step for all the respondents. Madam. But one is completed, rest of the 2 to 6 is not completed.
No, respondent number 2 to 6, you have not taken steps. The office note says,
Then madam, allow me to take a step upon the respondent number 2 to 6.
why you are taking charge? See the record and submit straight away. You wanted that court should also always point out. And if the court failed to point out, you'll take advantage. Don't
No.
see the records in the orders. Okay. In view of the office note dated 21/11/2025, Mr.
I'm appearing for the time. Madam.
Okay, Mr. What was your good name?
My name is D. Adwan.
D?
D. Adwan.
Okay. T or D?
D.
D. Adho, Lana Council appearing on behalf of Mr.
D. Time.
T. Time submits that inadvertently, we could not take steps upon the respondent number 2 to 6. Therefore, pray for the 1 week time to take steps upon the respondent. Stop prayer aloud. Steps upon the respondent number 2 to 6 by a registered post with AD be taken within a week from today. Start. Okay. Please this matter after 3 weeks.
Yes.
Okay.
Item number 17.
My lord, same madam.
Similar order?
Yes.
Okay. Yes, similar order.
Madam.
Item number 18.
Lordship in this. Yes,
In this matter, I'm for the respondent. And we need 1 week's time to file reply in this matter.
Hard miss.
M. Bori Lordship.
M. Bori, Lana Council for the
Petitioner.
petitioner. Mr.
A Gamre.
A.
Gamre.
Gamlin, Lana Council, appear on behalf of the respondent. Respondent number?
Sole respondent.
Sole respondent. Have you filed, okay, and by filing Wakalatnama and praise for. You want to file objection?
Yes.
Affidavit?
Yes.
Okay. Affidavit in opposition. And press for some time to file necessary affidavit. Huh? The prayer is allowed. List this matter after 3 weeks.
Obliged.
Okay.
Item number 19.
May I please, Your Lordship? This matter, office note, my lord, dated 21/11, says that notice upon the respondent 2, 4, and 7 is awaited. And in respect of respondent number 6, it was returned unsubmitted. So we may be allowed to take fresh steps upon the respondent number 6, madam.
Okay. The office note dated 21/11/2025 reflect that the notice upon the respondent number
6
return
unsubmitted.
unserved. No, just a minute. The notice upon the, what about the others? You want to take fresh steps upon the
I am
others?
for
also?
8, my lord.
You are for 8.
8.
I am for 2 and 3.
Okay. Earlier also you appeared?
I have already filed my.
Okay, hard, mister, you are for
It cannot.
Lana Council for the petitioner. Stop. 2 and, who is for 1?
I am for 1.
Okay. Yes, Mr. Soki, Lana Council. Lana Council, Mr. Soki, appear on behalf of the respondent number 1. And you are for
2 and 3.
2 and 3?
Yeah.
And Mr. Ingo for respondent number 2 and 3. And,
Your Lordship, I'm for respondent number 5.
okay, Miss,
I'm speaking on behalf of Learning Council and
okay, Miss, you are Miss?
Dear.
Appearing on behalf of who is council?
Emma.
For respondent number 5. And Mr.
S count for S respondent 8.
Let's count for respondent number 8. Staff, the office note dated 21/11/2025 reflect that the service upon the respondent number 4 and 7. That means since you are appearing on behalf of 2, so it's only 4 and 7.
4 and 7 is
4 and 7 is still awaited, and the notice upon the respondent number 6 return unserved. So in view of the above, the Lana Council for the petitioner prays for allowing him to take fresh steps upon the respondent number 6. Step prayer allowed. Step for notice upon the respondent number 6 by a registered post with AD as well as by user process within a week from today.
And nowadays, my lord, speed post, I think registered AD is not there.
Not okay, then speed post
Now,
by way of speed post. Okay, within
1 week.
1 week, within a week, 7 days from today. Stop, huh? List this matter after.
Can it be on 19/12, my lord?
Is it okay?
Fine.
Okay, as requested by the Lana Council for the parties, let this matter be listed again on 19/12. Okay.
Obliged.
19. Okay. So
19.
unless you wanted this case on Saturday, we can see, huh? When?
Friday.
19 is Friday.
December.
Oh, yeah, December 19 is, yes, Friday. He probably will not come on that day.
Develop.
Yes.
Item number 20.
My lord, I am appearing for the respondent, my lord.
For
I am appearing for the respondent, my lord.
respondent, sole respondent.
No.
There are
Out.
two respondent, your
Two respondent.
when I sole respondent, your lordship. Damle Kandu.
I is for what?
I is for condonation of delay for 75 days, your lordship.
You have any objection?
Yes, my lord. I will file my objection.
75 days, you want, have
70.
objection?
And that also
What is this case?
75 days is, I just
CRP.
apprised your lordship. 75 days is because I had approached before the Sessions Court for appeal, your lordship. Since the Sessions Court did not have the jurisdiction to entertain the appeal, your lordship, after the appeal has been done by.
But since you want to file objection,
Yes,
what
Lord,
can you do? Okay,
2 weeks time may be long.
okay.
And if your lordship kindly give me
Ms.
weeks.
Tijini, Land Council for the applicant is present. Stop, Mr.
The other one.
The other Land Council appearing for the first time?
Yes.
Okay, put appear on behalf of the sole respondent.
Sole
Sorry,
respondent.
respondent number
Sole
or
respondent.
sole respondent. And prays for some time to file objection. Prayer allowed. List this matter after.
Your lordship, if your lordship kindly give
Two-
me a date of 11th of December, which falls after 2 weeks, your lordship.
Okay,
11th of December, your lordship.
okay. As requested, let this matter be listed on 11/12. Okay.
Deeply.
Item number 21.
In the meantime, you file affidavit, okay? Objection, okay.
Same may be recorded, your lordship. In the meantime,
In the meantime, the respondent shall file their affidavit, objection,
deeply.
if any, stop.
Item 21.
21,
Yes, your
yes,
PCR not yet received.
call for,
Yeah, it was called for not yet received.
not yet received, received.
Office report.
Okay, this is criminal petition. Yes,
Quashing of FIR, my lord.
yeah, FIR.
Yes.
Which court?
CGM,
CGM where?
UPR.
UPR?
Yes.
Why it is?
On the ground of that mutual settlement, my lord.
Okay. No, then.
Charge sheet
you said
already
that
has been filed.
Charge sheet already
Yes,
filed.
yes,
Trial begun.
yes. I already.
Under what provision section?
Your Honor,
Offense, okay, 448, 352.
yes, only one section is non-compatible, my lord.
Two, which one? What?
Your Honor, this 294.
294.
Yes.
So when can you produce, Mr. Tado? It's a joint petition.
Yes.
Sorry, December. December. Oh. Have you annexed the last order of the?
Yes, my lord. Yes.
Where page?
Order page, Your Honor, 46. 46. The proceeding is pending for priming or charge, Your Honor. CGM UPR court order.
16/9/25.
46, Your Honor.
Page 46.
46.
Date 16/9/20.
Yes, yes.
25.
Your Honor, the matter is already settled by the both party and the charge is already framed.
13/11.
Yes.
6 and 30. What happened on 13/11? Okay, let him produce the record. Okay.
If Your Honor may allow, then any date of December, my lord.
Miss
T. Jim.
T. Gini. T.
Zim. ZIM.
Zim.
Yes.
Okay, Land Counsel for the petitioner. Mr. Tado Lane, additional PP. Press for some more time. So TC is called through registry.
Registry.
Okay. Mr. Tado is also present. Trial record is still awaited. Staff. The registry to issue reminder for the scanned copy of the trial court record. Staff has requested that this matter be listed. When you said
Any day of December, my lord.
of 15 of December.
Obliging.
Hmm?
15.
Okay. Yes.
Oblige, my lord.
Item number 22.
Yes.
Lordship, I am counsel for the petitioner in this matter.
Okay.
Looking at the records, it is found that the TCR has not been received and
Not yet
service
received.
is also pending.
Okay.
It is my humble
This is
prayer,
also
Lordship.
criminal petition.
Yes, Lordship.
Okay.
My humble prayers, Lordship, that we may be kindly allowed to take service via concerned PS or CPS.
Jet. Upon respondent number,
Sole respondent.
no, sole respondent.
Lordship. Oh, just two respondents, state and private respondent.
Proximate.
Hmm?
Proximate.
It's a POXO matter. Okay. Okay. Mr.
Abanso Gamre. A Gamre.
A. Gamre, Land Counsel for the petitioner, also had Mr. Gitado, Land additional PP for the state stop. The office note dated 21/11/2025 reflect that the trial court record. Sorry. So the notice upon the respondent number 2 is still awaited. The registry shall issue reminder for the scanned copy of the trial court record. Stop para. The notice upon the respondent number 2 or 4? 2, okay, respondent number 2 is also still out. Just a minute. You want to take fresh steps?
Yes, via
Okay.
OC concerned PS or CPS.
Okay. Okay, then the land counsel for the petitioner prays for allowing him to take fresh steps upon the respondent number 2. Prayer allowed. Service of notice upon the respondent number 2 by a register. The speed post. Oh, through by a concerned PS. Okay. Through the jurisdiction of where is the jurisdiction of PS?
Pasigat.
Okay, jurisdiction of police station to be routed through the registry. Okay.
Rotate through registry.
Okay. Within a week.
Within 2 weeks.
Within 2 weeks. Okay, within 2 weeks. Stop. Please this matter after 3 weeks.
Lordship,
4 weeks.
2 weeks, Lordship, because the next hearing
When-
in the trial court. A fixed date maybe kindly give, much appreciated.
No, you are going to take steps within
2 weeks.
within 2 weeks. Okay. Supposing if you take the last day of 2 weeks, then when it will reach? You are seeking 2 weeks means you are going to take steps in the last day of the second week, isn't it?
Lordship, we will take the steps by first week and the matter.
Okay. Then why you are asking for 2 weeks? Okay, within 1 week. Okay. At least this matter after 2 weeks. Okay.
Item number 23.
Your
Yeah.
Lordship, I'm for the appellant here.
Okay,
The
you are
insurance
for
company.
the applicant.
Appellant. Your Lordship, there are 2 ayes pending in this make appeal.
Who is for the applicant?
IA 271, the respondent
Lord.
claimant, they are
Okay, you come to your own place.
I'm the
You are for the applicant.
My lord, for IA number 271, I am the applicant.
Okay, the IA is listed. You come to your own place.
It's fine.
Otherwise it confused.
Yes, my lord.
We see this side as a red color, this side is a black color.
So that, this IA
Yes,
is
this
for,
IA for
direction to pay 50% from the awarded amount. And they have filed in one IA
direction to
direction to appellant. They are the appellant
appellant to
in
what?
MSc appeal.
Uh,
And
seeking direction for what?
for direction for depositing 50% from the awarded amount.
Why?
My lord, it was a
Whether the MS MAC appeal has already been admitted?
Yes, your lordship. Admitted, my lord.
Okay, no stay.
No, stay. We have filed stay petition is filed.
Have you filed stay petition?
Yes, IA number 234.
Okay, we'll dispose of that IA 234.
Yes, your lordship.
Where is that?
IA 234 in MAC appeal 22.
Okay, then you deposit 50%?
Yes, your lordship. But
Okay.
regarding the, your lordship, releasing the 50% to the
Let them
claimants,
file application,
they have filed an application praying for releasing of the 50% in
not
their,
yet deposit.
not yet deposited.
Then you take that money first.
Your lordship, my lord,
How without deposition? No?
no, my,
It is yet to
actually,
be deposited.
actually there is some typical typographical mistakes that
Why
in
you
my
make
prayer
such-
section I have also mentioned there.
Why you always make such mistake?
Yes, my lord, in my prayer section I have mentioned that with the premises above, it is therefore pre that your lordship would be pleased to admit this petition in view of the facts and
Just a
circumstances
minute. We
hearing.
will dispose of this 2, 3, 4. Huh?
Yes, my lord.
Mr.
M. Tangsang.
Learned counsel for the applicant insurance company. Staff. Huh? Which insurance?
SDFC.
SDFC.
Yes, your lordship.
Applicant HDFC Ergo General Insurance Company Limited. Staff. Huh? Para. This is an application filed under Order 41, Rule 5, read with Section 151 of the Code of Civil Procedure. Speaking. Where have you stated that for stay of?
Yes.
Where is the prayer? You have not made such statement.
In page number 5, your lordship, in the premises aforesaid, it is provided.
Seeking stay of the operation of the judgment and award dated 12/6/2025 passed by the learned member Motor Accident Claims Tribunal, Bomdila, in MSC case number 18/2023. Stop, huh? Since the connected appeal has already been admitted, comma, the operation of the judgment and award dated 12/6/2025 passed by the MSCT Bongila in MSC case number 18/2023 shall remain stayed subject to the condition that the applicant stroke appellant deposits 50% of the total awarded amount before the registry of this court within
4 weeks.
4 weeks from today. Stop. Para. With the above this, I stands disposal.
My lord, withdrawal may be allowed.
Where is your withdraw petition?
My lord,
271
271.
can be allowed.
Your lordship, in the event that if we succeed in the appeal, whether they will be redepositing to our account.
Let them sign bond. Okay.
My lord, they have filed the MSC appeal not challenging the quantum of amount, not challenging the any police record, any GR record, any 279. They have only challenged only on the limitation. We had filed in the MSCT case, there was delayed and limitation petition was allowed. On that ground, they have challenged.
Okay, I again heard Mr. D.R. Das, land counsel for the applicant, 271. Also heard Mr.
M. Tang Sang.
Okay, land counsel for the respondent insurance company, staff of para.
Your Lordship, regarding the issue of that, it's pending before the Honorable Supreme Court. This whether Section 166(3), whether a condonation application can be allowed in order to entertain an application under 166.
No, but since we are filing application, appeal,
Yes, Your Lordship.
and where your 50% deposition is necessary,
Yes.
you have to deposit.
Yes, we will deposit.
We'll ask him to sign a bond,
Yes, Your Lordship.
indemnity bond, okay? By an order dated, today's, okay? This court directed the respondent stroke appellant insurance company to deposit 50% of the total awarded amount before the registry. Stop, By this application, the respondent, by this application, the applicant stroke respondent, the applicant stroke claimant prays for release of the amount to be deposited, amount directed to be deposited, the release of the 50% amount directed to be deposited by the appellant insurance company. Stop. The learned counsel appearing on behalf of the insurance company has no objection. However, he prays for securing with he prays for a rider to execute a bond. Stava. Para. In view of the above, it is directed the registry, and it is provided that the registry shall release the 50% of the total awarded amount to be deposited by the insurance company to the applicant claimant on execution of an indemnity bond of the like amount on proper verification and identification by their advocate. Okay.
Yes, my lord.
With the above this, I also stands disposed.
My lord, Supreme Court has passed one judgment regarding that.
What do we have to do with that?
Yeah.
Okay.
Oblige, Your Lordship.
Yes.
Item number 24.
May I please, Lordship? Lordship, this is IA for condonation of 28 days delay in filing a connected make appeal.
Yes, you have objection.
My lord, I am appearing on behalf of the respondent number 1.
Respondent number 1 has an
Yes.
objection.
United in that, but other 2 respondents are there.
There are other two. Who are the necessary parties? The challenge is on what? Challenge in the make appeal is on what? Quantum or what?
Quantum of compensation.
And who are these? Respondent number 2 and 3.
These are driver and owner.
They are
of
not
the
connected since you are challenging on
Yeah.
quantum. Then you have to say whether you have a
No,
objection. Okay. Heard Mr. M. Tara, learned counsel for the applicant. I also heard Mr. U. Deka, learned counsel appearing on behalf of the respondent number 1, United India Insurance Company. Stop. Sarah. The learned counsel for the applicant submits that. Respondent number 2 is who?
It's driver of the vehicle.
Or I thought that this is lady Sita.
No, no, no.
Sita, Sita Saja.
Yeah,
I thought how this lady can be, okay.
driver of the
Okay,
pending vehicle.
the, submit that the respondent number 2 and 3 being driver and the owner of the vehicle
yeah.
is not a necessary party for the purpose of disposal of this IA. Therefore, pray for striking of their name. Stop. In view of the above, this, the name of the respondent number 2 and 3 stands struck off from the course title at the risk of the applicant. Paraha. This is an application filed under Section 5 of the Indian Limitation Act 1963 for condonation of 28 days delay in filing the connected appeal. Stop, huh? The ground for delay in not filing the connected appeal on time has been stated in paragraph, which paragraph?
Paragraph 3.
3.
Yeah, 1, 2.
Paragraph
Paragraph 2, 1, 2, 3, 1,
3, huh?
3.
Of the condonation application. Stop, huh? Upon hearing and on perusal of the aberration made in the above mentioned paragraph, comma, this court is satisfied that the applicant applicant was prevented by a sufficient cause in not filing the connected appeal within the stipulated time. Stop. Moreover, the respondent insurance insurance company has no objection condoning the delay. Stop. In view of the above, paraha, the delay of 28 days in filing the connected appeal is hereby condoned. Stop. With the above, this IA stands allowed and disposed of. Okay. Then this has already been registered, make appeal.
Yes.
In Maine.
Yes.
Mr. M. Tara, Land Council for the appellant. This is an appeal filed under Section 173 of the MB Act 1988 for enhancement of awarded enhancement of the amount awarded. So award dated. What is this?
The Kamla Sana.
Huh? I think you have to correct it. There is no date. I have never seen this date, 00 and
22/7/2025. 22/7/2025.
I think this, I will not pass any order. You have to correct it. First. There is a 00.00.2025. This is new date for us. You have to correct it. Will not pass any order to
Yes,
this.
yes.
Okay, you correct it first. Okay.
Item number 26.
Then we'll say in the appeal, Mr. M. Tara, Land Council for the appellant, submits that there is an error, a typographical error in the course title of the appeal regarding the date of the the date of the awarded date of the date of the judgment and award, and therefore he prays for allowing him to correct the same stuff. The prayer is allowed. Okay, you file. I think probably you have to file amended course title. There is a defect in others. prayer is allowed, the the appellant shall file corrected, amended course title. The registry shall do the needful. Okay. Okay. List is matter after
4 weeks, 4 weeks.
4 weeks.
Yes, sir.
Okay.
Yes.
Yes.
Item number 26.
None appears on call. None appears for the parties on call. Or you're there.
And for the state, Your Lordship.
None appears on behalf of the appellant, whereas Ms. Jeannie T. Jeannie, learned additional people is present. In absence of the appellant, the matter stand adjourned. List is matter after 3 weeks. Okay.
Item number 27 and 28.
Yes.
May I please, Your Honor?
Yes.
Lordship, this is a POXO matter. Criminal Appeal 02. I'm appearing in Criminal Appeal 02 as amicus, Your Lordship.
Okay.
And these two Criminal Appeal 27 and 28 are connected, arising out of same judgments.
Okay. Being a bit for
Number one.
Sunil Roy, Vinod Kaur. I think so can we complete it it's up to 4:15 or 4:30? The court timing is
4:30 it should be.
4:30. Can you complete? If we divide, then you get 15 minutes. 15 minutes is so say 17 minutes each. Can you complete?
Lordship, in this matter, conviction sentence was for 5 years, RI.
Okay.
Prison.
When it
And
was done?
already sentence has been completed.
Sentence completed?
Yes, Your Lordship.
Then what more remains?
But
he is still inside.
No. But that instruction I don't have, but
Then it has become infractious only then. Then why you are ready to what on what point you are ready to argue?
since this is a criminal appeal, so it has to be whether it can be dismissed on infraction.
It has become infractious only because he has completed.
Yes, Your Lordship.
When it was filed?
This was filed in the year 2022, Your Lordship. 22, and he was
He has
arrested
completed and then also
as on
discharged
today,
also.
yes, as on today, it's 5 years, 11 months, and 27 days.
Okay, his
As on
conviction
today,
is 5 year only.
His conviction was
Now it has become infractious only. Nothing to, I think, adjudicate here when the matter has become infractious in the criminal because he has done everything is
additional
finished.
PP can suggest in that.
PP, additional PP. So anything, it has become infractious only.
Yes.
You want to confirm it? We'll get it listed tomorrow then.
No, it has been, I think it's in the order, court's copy that the jail authority has given a intimation with regard to his release from the.
It's there.
I think it's there.
It's there.
His
Where?
completion report should be in the court's record, Your Lordship. It might have been flagged, and it was also recorded on the previous occasion.
No, see, this is engagement. Yeah.
What लग रहा है? नहीं ये कोर्ट का कॉपी नहीं दिया था वो लोग ना ये तो लोअर कोर्ट का एक था कोर्ट का कॉपी है मुझे in person treatment program.
Which jail?
Your Lordship,
Your Lordship, just give me the file, Your Lordship. I'll just
Okay,
go
which
through.
file?
It should
The appeal.
appeal file, Your
Okay, give it to her. But we have to record that at least. No? So he was arrested and sent jail,
Yes.
and thereafter he completed. We have to record that.
In the judgment also, it's reflected that he was arrested on 2019, Your Lordship, in the judgment.
2019.
Yes, Your Lordship.
Okay.
In page number 76,
Okay.
para number 47.
So there is only one accused in both the case or different accused.
There are two accused.
Both have them.
Common judgment.
Both of them have completed.
Yes. Yes.
Okay.
Sure, you like this. Maybe you like his new. Yeah, yeah. दूसरा वाला भी
Hard Miss and Anju, landed amicus curiae for the appellant.
Your Lordship, it just give a second, Your Lordship. Because I'm not able to find it. I'm not. एक दूसरा वाला file, I think number 20.
Unless he was released in between on parole or otherwise, then if he has completed, we can calculate from the date of arrest and then that when he was sent to jail in execution of the conviction.
Because there was another case where for दूसरा case.
Judgment is of 2022 and he was arrested. FIR was 30/11/2019 and he was arrested on 30/11/2019.
And in the
And it
judgment, whether
says-
it has reflected and
Yes,
it has
and
been since then. He
and
was
since-
not released on bail.
And since then, they are behind the bar, it says.
Okay, since then, it is on record.
Yes, it's on record.
Okay.
In the judgment, Your Lordship,
Okay.
in paragraph 47.
Your Lordship, in that case, may just to affirm it, Your Lordship may call for the same from the respective jail superintendent, Your Lordship. Information.
It's from district.
The record is clear. Can you just obtain instruction only?
Only instruction, Your Lordship.
Okay, because they will not be able to find the record immediately.
Yes, at least from.
And at least from telephonical, because they know he was here and he has been released after completion.
Yes, Your Lordship.
So that information on instruction only. So can you fix this week's any day?
Yes, on coming Friday, otherwise.
Okay. Also had Miss Jenny for the state and Miss Ndang for the for legal aid counsel for the legal aid counsel for the victim staff. It is submitted that the accused has already completed his sentence and have been released released from the jail. Released from the jail. Stop. However, Miss Jenny waits for some time to confirm this information. Waits for some time to obtain instruction with a view to confirm this information. Stuff. The prayer is allowed. Let this matter be listed again on
27th, otherwise.
27. Okay. 27. Okay. And then in another case, Binga will be for appellant. Binga for appellant. Okay. And rest same. Yes.
Obliged.
What about this 32 and 33?
Delivery of order.
32, 33 also delivered. I don't remember. This morning also I asked, what about this other? Delivered, na? Okay.